Everybody has gone. Here are a few reasons why the Iowa A.L.F. investigation is a complete and utter fraud. 5 years after the Animal Liberation Front raids the University of Iowa, the government launches a prosecution that is a fraud on its face. In late 2004, morning workers arrived at the specimen laboratories to find $450,000 in property damage to equipment and 401 animals missing. The graffiti left at the scene read, "Science, not sadism," and "Free the animals." In a long communique, the Animal Liberation Front took credit. A few reasons why this investigation is a complete fraud is 1. Carrie Feldman was 15 at the time of the raid. Carrie Feldman, incarcerated for refusing a testimony to the grand jury, was a 15-year-old sophomore in high school at the time of the raid. Yet a judge has stated the government admitted it sought Feldman's testimony because it believed she had knowledge of the break-in at the University of Iowa laboratories in November 2004. And in a dissenting option on Carrie Feldman's denied motion for release, a judge said, "I am concerned by the necessary implication raised in this matter that the government is seeking Mrs. Feldman's testimony for the sole purpose of gathering additional information to support its indictment against Scott Dermott." Well, Scott was 17 at the time of the raid. Unlike Feldman, Scott is accused of direct participation in the A.L.F. action. Prosecutors have stated they believe he is featured in a video made of the raid. 17 at the time, Scott is implicated in an action that has the appearance of one of the most complex and expertly executed in the Animal Liberation Front's history. According to the media reports and A.L.F. communiques, activists picked locks, bypassed 4 layers of security, which is damn hard to do, used stolen keycards and access labs, and removed 401 animals from the building undetected. At 17, Scott is accused of an action requiring this level of skill. Also, Scott was not told he was the target of the grand jury. Furthering evidence, Scott's indictment was reprisal for his refusal to testify. He was not told, repeat, he was not told he was the target of the grand jury when subpoenaed, as required by state and federal law. This bolsters the case that Scott's indictment was motivated by spite and was an afterthought to his refusal to testify. The statute of limitations had expired. The indictment was issued 4 days after the 5-year statute of limitations had expired. Federal cases have a 5-year statute. After 5 years, those cases become invalid. The district court abused its discretion when it found Mrs. Feldman in contempt of court because it failed to consider a significant, relevant factor, i.e. the statute of limitations had run out on the crime for which the government seeks Mrs. Feldman's testimony. The government itself cites no authority for the proposition it can be abused and used the grand jury process to compel a witness to testify regarding a crime for which the statute of limitations has expired. Another clearly issue that once again shows that this investigation is a complete fraud is the indictment is unconstitutionally incomplete. Scott's original indictment was shockingly vague. It failed to provide the following basic information. And I will repeat this very closely. It failed to provide the following information: the elements of the alleged offense, supporting facts and circumstances the law alleged to have been violated, identifying an element of interstate activity, providing a state range of the alleged conspiracy, where the conspiracy is alleged to have taken place, and basic information as to what he is accused of. The one-page indictment was particularly voided of any information in which Scott could prepare a legal defense, including any information on what crime he was alleged to have committed. Scott is charged under the Animal Enterprise Terrorism Act, a law that did not exist until 2006, 2 years after the University of Iowa raid. A quote from the motion to dismiss the indictment respectively moves that his indictment be dismissed since the charges brought against him are under the statute, which was not the law at the time of the alleged offense. The only evidence the prosecutor has stated to support Scott's involvement is this resemblance, not a solid confirmed identity or ID, but a resemblance to an individual in a video of the raid. The video of the rescue taken by the A.L.F. is a very grainy black and white film showing activists holding animals onto carts and taking them from the lab. The video would be damning evidence, if not were all activists on the video not wearing black masks, meaning that the FBI and the DA cannot 100% identify Scott in the video because all the activists were concealing their identity. So their only piece of evidence isn't really evidence. It is hearsay. They have a theory. But a theory is not solid evidence. It's not the grounds to move forward in a case and prosecution. Last but not least, to tie this all together, Scott is not a vegetarian. In perhaps the most absurd example, the government made the folly of charging someone of an A.L.F. action who is not even a vegetarian. In fact, the man accused of conspiring to rescue rats from a lab is an avid bow hunter. That's right, Scott not only is a bow hunter, but he's not even a vegetarian or a vegan. In conclusion, the jailing of Kerry Feldman and indictment on Scott appears to be motivated by the following factors: desperation, spite, and or the need to freeze his status of limitation and buy time to build a sustainable case. The combined factors make the University of Iowa A.L.F. case among the most egregious examples of overzealousness. Take care. Bye.